Okay, so good afternoon, everyone. A very warm welcome to all our distinguished faculty members, participants, and guests to the final session of our faculty development program on alternative or appropriate dispute resolution (ADR) for Vikasit Bharat, which is organized by Faculty of Law, SRM University, Sonipat, Delhi NCR, and in collaboration with Law Teachers India. So, over the past sessions, we have explored the vast landscape of ADR, and today we conclude with a subject that truly lies in the heart of dispute resolution, that is, the mediation process and techniques. We are privileged to have with us a speaker who not only brings academic depth but also practical, real-world insights into ADR practices. Before we begin, allow me to formally introduce him to you. Our speaker for the concluding session of this FDP program is Professor Akash Gupta, Associate Professor and Assistant Director at the Center of Alternative Dispute Resolution, Jindal Global Law School, and visiting faculty at NLSIU Bangalore, where he teaches arbitration. Professor Gupta's academic journey spans Tamil Nadu NLU Trichy and Stockholm University, where he completed his LLM in International Commercial Arbitration Law. He has also attended the Paris Arbitration Academy and the Hague Academy of International Law on prestigious full scholarships and sponsorships, adding a rich international perspective to his expertise. In recognition to his contributions, he has been appointed to the Young IAMC Steering Committee to 2025 to 27 by IAMC Hyderabad and was awarded Young ADR Academic of the Year 2023 by the Asia Pacific Center for Arbitration and Mediation. He is a prolific scholar. Professor Gupta has authored 10 Scopus Index publications in leading outlets such as Sage, Springer, Rootley, and Thomson Reuters. He regularly judges high-profile moot courts and ADR competitions like WIS, JESUP, and FDI, and has conducted workshops at 50-plus law schools. Please join me in welcoming Professor Akash Gupta for his session on mediation process and techniques. Over to you, sir.
Thank you very much. Thank you very much, Kalpesh sir. Thank you very much, Vijay sir, for giving me this opportunity to talk to the audience here and share some of my insights on mediation. So thank you very much, both of you. And thank you very much for this very kind introduction. Okay, so without further ado, let's start with the topic. I think you are able to see my screen. Perfect. Okay, so in this session, I think we almost have around 40-50 minutes for me. So we are going to talk about the mediation process, like how the process looks like, and what are the techniques, how you actually conduct these mediations. I know that you have had many sessions before me, so maybe my job is going to be a difficult thing because I have to give also a closure to this course. So before we get into this, what is that mediation entails of? Does mediation include some sort of decision making? For example, a mediator, let's say that there exists a dispute in between Vikas sir or Kalpesh sir, and they have the dispute. If they appoint me as a mediator, do you decide that Vikas sir has to pay 1 lakh to Kalpesh sir? Do you think there is a decision-making power in this process? Let's start with this question and build upon this throughout the session. Anyone who wants to answer this, you can just type on the chat box. Yes, I can see the chat box. Or if you want to unmute and answer, that's also fine. What do you think? Do you think there is a decision-making process involved, adjudication involved? You have to tell me this because this is the last session of this FDP. You can't say that you don't know. Okay, now we have an answer. So Kalpana ji is saying that no, very good. Please understand this. Basics of ADR. Adjudication is something which is within arbitration, which is within, let's say, litigation. But in terms of mediations, there is no adjudication involved. Okay, there is no decision-making power. What my job is as a mediator is to help Kalpesh sir and Vikas sir sit and discuss the issues. I'm just a facilitator. I can't say that Kalpesh sir, you have to pay 1 lakh to him, or Vikas sir, you have to pay this much. That's not my job. That's not my function. So we need to understand this basic before we get into the whole idea of mediation process. Now, somebody is saying on the chat box, it's a win-win. Do you actually think it's a win-win in all mediations? I'll give you an example. Let's say Kalpesh sir and Vikas sir. Kalpesh sir is the landlord. I'm really sorry, Kalpesh sir, Vikas sir, I have to use your name because I see you video, your face is visible, so I'm just using your example. But it's all hypothetical. Okay. So this is the caveat. Now let's say Kalpesh sir is the owner in Surat, and Vikas sir shifted there to teach for some law school in Surat, and he's the tenant. Now Kalpesh sir is saying that either you leave the house or you have to pay 20% increase on the rent. Now Vikas sir is saying no, 10% is the standard. You can't throw me out. Kalpesh sir is saying I'll pay you 1 month of rent. I'll pay you this, you have to vacate. Now there is this issue. Do you actually think in these petty issues also it's always a win-win? I know that all of the faculties who are teaching, majority of them come to you and say that, oh, in mediation or in ADR, everything is a win-win. What do you think? Do you think in all the cases you have a win-win situation? Not really. Please don't think that both the parties get 100% of the pie in all the cases. Some cases, yes, you can create a possible third alternative, which will be a win-win, you can call it, but not in all the cases. So please don't think that ADR is always about win-win. Second, everything in ADR is so cheap. No, it's not. In arbitrations, if you think that the retired Supreme Court judges who are sitting as an arbitrator, if you think that does not entail cost, I'm sorry, but that's not the clear picture, because when you go to court, you don't have to pay for the judges. What you have to pay is your legal counsels. But in arbitration, there are certain costs. However, arbitrations are much faster than courts. So this is the reason why people prefer ADR, people prefer arbitration, people prefer mediation. Okay, so this is the background I wanted to set. So now let's go to the first part of my discussion. So overall, we have where four stages of the mediation process and technique. The first stage is introduction and opening statement. Now, what is this? Think of this. Let's say this dispute in between Kalpesh sir and Vikas sir comes to you, you are the mediator. How do you actually start with this whole mediation proceedings? First things first, a mediator has to make sure that they introduce everyone, they establish neutrality. You have to also talk about your own qualifications, how many mediations you have done. You have to tell how the process looks like. Everything is confidential. You have to also talk about that parties can decide if they want to settle, if they don't want to settle, if they want to leave the discussion, they have all the rights. There is no mandate that once you do a mediation, do you think that it's mandatory to have a solution or a settlement at the end of mediation? Is it a mandate? No, there is no mandate that you need to enter into a settlement agreement. If you like the settlement terms, very good. If you don't like it, you don't have to settle. Now, all of this, who does all of this? It's the mediator who does this, right? Right after this, you have to also make sure that you have to establish control over the parties. So basically, who runs this proceeding? It's the mediator. Now, how this setup looks like. So let's create a scenario. A and B are two mediators. Okay. Then Kalpesh sir has a legal counsel X, Vikas sir has a legal counsel Y. So client counsel sitting on one side, client counsel sitting on another side. Then let's say you have two mediators. Now, what is the procedure for this? Fairly simple. You start with greetings. You have to also talk about your introduction, your conflict of interest. Let's say if Kalpesh sir works in XYZ organization and I'm also working in the same organization. Both of them sit next to each other in the office. Do you think I can be a mediator in that dispute? Let's say I meet every day, we hang out every day, we socialize every day. Do you think I have a conflict of interest? There exists some chances of conflict of interest because we, both of us, socialize, right? So conflict of interest, simple meaning is that if there isn't, some sort of relationship, doesn't matter personal, official, financial, through your company, through somebody has hired you, CA or whatever it is, in that case, you have to make sure that person is not hired as a mediator. Ask the parties to introduce themselves. What is the mm, ask the parties to introduce themselves. The language has to be finalized in the beginning. So let's say if the parties are well versed in Hindi, you can't be using English throughout because then it becomes a problem. You need to have live translators. So you have to first decide what should be the language of these mediation proceedings. And of course, whatever you note down, whatever notes you make, whatever is discussed in the mediation, everything remains confidential. Nothing from the mediations can be used in the court of law that you said this or you said that. All of this should be informed by the mediator in the beginning to all the parties. Now, the procedures that it's not mandatory that there needs to be a settlement. You have to also convey this to the parties that it's a voluntary process. Everything comes down to consent. If you consent to the terms, you have to abide by it. Otherwise, there is nothing going to be binding upon you. Now, this was in overall the introduction. The opening session, which you also call it, or some people also call it the opening statement. Now, opening statement for the mediators, this is it. For the parties, what they have to do, let's say if Kalpesh sir is the claimant, Vikas sir is the respondent. So right after the mediators does all of this, then Kalpesh sir has to talk about why that all of us are here. That what is the dispute about? So he'll talk about, for example, this rent dispute. I gave him a notice, he didn't reply, and then 20% increase, he's not ready to pay. It's affecting me, blah blah blah, whatever it is. He talks about all of this problem in a nutshell, and then the legal counsel actually tries to put forth some sort of agenda, which is like point one, two, three. These are the pointers for which we are here to actually discuss, negotiate, and try to find a solution. Once Kalpesh sir has done that, his or her counsel has given the opening statement, then the ball comes down to Vikas sir. Then Vikas sir replies back whatever he wants to make sure that he wants to include in the opening statement. He also gives his side in front of everyone, then the lawyer actually complements it. So the introduction session or the opening statement actually helps you finalize the agenda. Now, what is an agenda? If you have done internships or if you have worked for courts, if you have done arbitrations, you must have heard within the Indian legal market there is something called framing the issues, right? That there are one issue, there are two issues, there are five issues, all of this. So the nomenclature of issues is something which we don't use a lot in mediations. We call it agenda, like point one, point two, point three. Let's say point one is about how much rent needs to be paid. Point two is pretty much like whether there needs to be some sort of penalty for this, something like this. So agenda one, agenda two, all of this needs to be finalized in the opening statement. Now, whose job it is to finalize this? It's the mediator's job, but of course the parties help you that these are 5 pointers from my side, the other party says I have 2 points. Then the mediators try to jot down all of this together and find certain agenda. Like these are the 3 points which we have to do it. I'll give you an example for this. When you look at this FDP course, you must have seen that there are 15 sessions. It looks organized, right? That first session is this, second is this, third is this, last session is this. Similarly, when you know that these are the points of discussion, it's going to be very easy for you to actually go through the discussion. So this is called agenda, and this is something which is done in the first part of the session. Now, what is the second session or the second stage? Now, this is called joint session. Joint session, the idea of this session is to gather a lot of information from both the parties. The parties get a chance to pour their heart out, to tell them exactly what has happened, to explore different relationships, feelings, whatever accusations or whatever discussions they want to have. And this is the time where the mediators actually understands the problem, the dispute from both the sides, and both the parties feel heard, because this is the point where you actually discuss the whole matter. So of course how it works is that the mediator starts with, of course, claimant, and claimant narrates their whole case without any interruption. And then, of course, the other party can ask questions. Then the legal counsels discuss the legal issues involved, what suits the best for their own clients. Mediators can also ask questions, clarifications, make notes within this. And So all of this happens in the joint session. Now, in the joint session, there may be a chance that sometimes the parties starts to have accusations against each other, and sometimes the scenario is pretty much tensed, and you don't know what to do. In those cases, there is a requirement of having something called a separate session or a caucus session. What is this caucus? Caucus is that, let's say, I ask one of the parties and their counsels to go out, and the mediator talks to one of the party and the counsel alone. Now, this is the place where you can actually try to resolve the tension in between the parties. And you also try to gather more detailed information, more detailed things. And the parties can also share something like a confidential information. Because the party does not want to leak it to the other side, but the parties want to talk to the mediators alone. Now, this is called the caucus session. So sometimes it actually helps because then the parties feel more heard. The mediator is in a position to understand the problems in a better way. And all of this discussion within this separate session is confidential. The mediators cannot relate to the other side unless until they have an express approval of the parties. Okay, now if we look at the first three stages, the first one was opening. Second one was joint. Third one was caucus. And the last stage is called the closing session. Now, in the closing session, a lot of times you will see that there is some settlement. A lot of times you will see that there is no settlement. There is no mandate that the parties need to settle. A lot of times you must have seen this, not in the real lives, but in the ADR competitions, that when these students have the last 5 minutes or 10 minutes, they are in a rush to settle the dispute. You don't get marks to settle the dispute. Also, in real life cases, of course, if there is a settlement, it is actually good, but not all the cases gets settled. You can't force the parties to settle. Why? Because mediation is all based upon consent. If the parties consent to certain terms, then of course there is a settlement. Otherwise, there is no settlement. In case you have a settlement, then you have to make sure that all the terms and conditions of that settlement is written, signed by both the parties. The councils also signed it. In some of the cases, you also need to register it as an agreement between the parties. Now you also have something called the Mediation Act. So enforceability is a bit easier now instead of the previous regime when we didn't have a mediation law in India. Any questions so far? Anyone? Okay.
Yes, any question, query, participant, you can raise your hand or put the question in the chat box. Over to.
Okay. So the written agreement should specify all material terms. The language should be plain, unambiguous. It has to be clear and concise. If it is very confusing, then there will be a dispute arising out of the interpretation of the settlement agreement. So that is also important, how your settlement agreement is drafted. The obligations of the parties needs to be very clear. For example, if one of the parties have to pay 3 lakhs, there needs to be a timeline for that payment. There needs to be an interest rate mentioned if you flout the payment, and the duration of the payment. Is it a one-time settlement, or is it like some sort of, like let's say you have to pay 3 lakhs, 1 lakh this month, 2nd lakh in 2nd month, 3rd lakh in 3rd month. So all of these obligations needs to be clearly specified. If there is no settlements, if it's a court annexed mediation, sometimes you have to send a failure report that this mediation has failed. They don't ask for reasons now because of confidentiality. If it's a private mediations, not a lot of them ask you to do that, but some of the institutions ask you to share a failure report. Now, functions of a mediator, as we started from this example that whether a mediator can decide a dispute, the answer is no. A mediator cannot provide potential solutions. A mediator can only facilitate the discussion, help you discuss the issues, narrow down the solution, find out a solution. But a mediator cannot decide a dispute. Their job is to help you discuss and find a mutually agreeable solution. Okay, now this is important. In mediation process and technique, we think that whatever we say, it's very important, but sometimes we don't realize that body language. So based on a survey, 55% of the communication is coming from the body language. So for example, let's say I'm delivering this session, or let's say Kalpesh sir or Vikas sir has switched on their camera and they are looking very angry during this call, or I'm looking very angry. Do you actually think that you will listen to me in that case? No, right? But let's say if he's like Vikas sir is smiling, I'm smiling, we are having a better environment for this discussion, then maybe a chance that you'll go on with the flow. But what if I'm shouting in this class? Do you think your transmitters will be on to receive what I am saying? No, of course not. This is what the Gen Z students of mine tell me, that this is more like killing the vibe. There is a term called matching the vibe, then there is a term called killing the vibe. So communication is very important. How you communicate, your body language. So let's say that you're sitting in a mediation proceedings and you are always looking outside the window. Do you actually think it's a very good style of being participative in a mediation proceeding? Not really, right? So body language is very important, and according to a survey, it's 55% of the 100% of the things which we communicate. 38% is the attitude, the demeanor of your communication. Only 7% is transmitted through words. So communication is very essential within the mediation proceedings. So how you communicate, how's your tone? You must have heard about, that your tone is not good. What you said is not a problem, but your tone was not good. So tone is also very important. All of this is very important when you go for mediations. Why all of these is important? When the two parties want to resolve their disputes, if they are if they would have been an expert of mediations or negotiations, why there is a need that they need to hire you as a mediator? There is a reason why they want to pay for a mediator, so that the mediator takes care of all of this discussion. So a mediator has to be very good with this communication, including, of course, your legal counsels. As a client also, you have to have a good communication, but it's not your job to be a good mediator, to be very good in communication. But as a legal counsel who's taking a part in the mediation proceeding, or as a mediator, you have to learn this. Now, requirements for effective communication: simple and clear language, avoid difficult words, phrases, you have to be precise, logical, and you have to be a patient listener. You must have experienced this, that sometimes when you are speaking, a lot of your friend circle, your senior, juniors, or maybe your students, maybe your co-workers have a habit of cutting you off. So there is a trick to that. Every time somebody else is speaking, you count something like 101, 102, 103 in your mind. Once 3 seconds are done, 101, 102, 103 takes 3 seconds, then you speak. So you have to make sure that you don't cut each other off. Sometimes it's not about how much you speak, it's about how much you convey and how much you listen. So all of this is very important in mediation. And active listening is something which is important, which I was actually referring to: body language, empathy, asking the right questions. Asking the right questions are very important, because sometimes what the parties are saying or what the other side is saying, it's very confusing. If you don't ask for the clarifications at the right point of time, high chances that you are going to misinterpret it. So you have to ask the right questions right there. Now, body language, I'll give you an example for this. Let's say that you are the mediator, and when party A is speaking, you are looking at party B. Do you think it's a good sign? You have to make an eye contact. right? So eye contact is important. How you sit is also important. So let's say that you are sitting in a mediation proceeding and you are always sitting like this. Let's say if I teach like this, do you think you'll be more interested when I have a laid back attitude like this? So how you sit, how attentive you are, whether you are listening to the other person, whether you are making an eye contact. And the rule is fairly simple that you leave 1/3 of the chair from the back, you lean towards the table, you put your hands on the table, you try to make an eye contact. If you have a smiling face, please smile. If you don't have a smiling face, you don't have to. But please don't react to things what the other person is saying. So let's say if Kalpesh sir is saying something, let's say I'm 5 minutes late, and the moment I join this call, he says something that there are some people who are late, then I'm like, why are you saying like this? Facial expressions are also important, right? So if let's say, even if he says something like that, what I have to do? So usually I have this face, so I'll keep this face. I'll not react to it, right? So you have to make sure that you act professionally when you are in a mediation setup. Because once you lose this bridge of communication, it becomes a problem for you. Okay. Asking the right questions, we have already discussed this. Now, I'm not going to cover this because I'm pretty much sure all of this is discussed, but just this example of the different styles of negotiation. Have you covered the example of the orange pulp and the peel?
Yes, yes, yes.
This is covered, right?
Yes. एक जूस
Okay,
का
very
एग्जांपल
good.
हो गया है and then
Okay, so if that is already covered, why don't you tell me that uh, also, is this also covered? Distributive bargaining was, I'll give you an example. Forget about all of this. Two examples, okay? One example is that let's say that you have this auto driver who's saying that I'm going to charge you $200 for a ride, okay? And forget about this, let's use the orange and peel example itself, which is going to be very relatable because you have already covered. I'll use the same example and tell you which one is distributive, which one is integrative. So let's say two kids are fighting for this orange, one orange which is there in the house. One wants the peel, one wants the pulp. Now, what is the potential solution to for this? Two kids, A and B, one orange in the house, and both of them, one wants the peel, one wants the pulp. Will you cut the orange in half, divide it, or what will you do? Because this is already covered, it should be an easy question to you guys. How will you resolve this fight in between the kids? Anyone?
yes, participant, please raise your hand. Kalpana,
If you don't raise your hands and volunteer, maybe Kalpesh sir or Vijay sir will start pinpointing, and then you have to answer. If you don't answer, you don't get the certificates.
yes, yes. Now we'll be starting this way only. जितना आंसर दिया है then minimum. Yes, yes. Kalpana, yes,
Sir,
please.
what is
Yeah.
the interest about what is the need of either of them? Like one needs the peel for some
Yes.
reason, other needs the only pulp of it. So it is possible, and it understood. Okay, fine. I let go my share of peel, and the other person says I'll let go my share of pulp. So it is an integrated kind of thing, not a distributed equal distribution.
You made my job easier. Thanks to you and Dr. Poonam ma'am also. You guys are right that if one of the kid wants the pulp, the other wants the peel, you remove the peel, give it to one kid, and you give the pulp to another one. Now, this is what we call an integrative bargaining. Integrative bargaining, this is the example. Distributive bargaining or distributive style of negotiation is you divide the orange in half and you give one part to one person and another part to another person. When you are a negotiator, let's say you are a counsel representing a client, or let's say when you are a counsel in the mediation session or you are a mediator, you have to put your lens of distributive or integrative. Integrative style, not the distributive one, because you try to maximize the results, the outputs for both the parties. And this is a classic example of a win-win situation. However, there is a caveat. Not in all the scenarios you can do this win-win situations. Of course, in some of these scenarios, it's not applicable. But in some situations, you can do this with certain innovative thinking, out-of-box thinking. So you have to make sure that you use the lens of integrative style instead of distributive style. Okay. What is an impasse in a mediation proceeding? Impasse is pretty much like a deadlock. Let's say that both the parties are started to fight during the mediation and there is no way out, that they are listening to each other. There is a deadlock. There is nothing moving forward. It's more like a circular argument. It's more like a circular discussion. You are stuck with issue one, there is no discussion. So there are two things which you can do. One is that you park that issue agenda for some time, you move to another one. If that's not possible, you have to call for a caucus. You have to make sure that you talk to the other side or one of the parties alone. Otherwise, it's going to be a problem because then the discussion will take you nowhere. Okay. Now, roles of advocates, we have already discussed, like the roles of counsels when I was discussing for the last 30 minutes. So we already know this. Okay. Ethics and code of conduct for mediators or also for the lawyers. Everything, the most important thing is everything is confidential. You can't relay any of these informations. You can't use it in the court that, this client said this client accepted that they did this wrongdoing. You can't. Why? Because the Mediation Act has a section which clearly provides everything discussed within the mediation proceeding is, of course, confidential. So anything decided, anything discussed, all the notes, even if you write notes that Professor Kalpesh said this, if I take that in the court of law, will that be an admitted evidence? No, the courts will reject it. Why? Because of confidentiality. Now, also during the arbitrations, the section 30 of the Arbitration Act provides that you can encourage, as an arbitrator, you should encourage settlement. So you can do mediations also in the middle of the arbitration if the parties want. Section 62 and 63 of the Indian Contract Act enable parties to arrive at any alternative solution in respect of the bargain that they have made. Disclosure of information submitted by the parties to each other, whether that is confidential, it is covered under Section 23 of the Evidence Act. However, now we have a special is going to be confidential. Okay, so with this, I have reached the end of my session and I open the floor for questions. I think we have almost 10-15 minutes here for the Q&A. Perfect. So we open the floor for questions. If I'm not able to answer your questions here, you can scan the QR and you can text me and I'll get back to you. So we open the floor for questions. You can do it through the chat or you can just unmute and ask your questions.
Participants, you can just raise your hand and you will be unmuted to ask your questions.
If you don't ask questions, I'll presume that my lecture was excellent, that all of you understood everything.
It indeed was, sir. It was.
No, I was just kidding. Any questions on this or anything also in general with ADR, with, let's say, how to pursue this career or anything relating to ADR, it's fine. We can talk about it. Sir, can you please help to unmute
Yes, yes.
Kalpana ma'am? Yeah.
Yes, I have made a setting. So any participant, please unmute yourself and your community. Yes, please.
Sir, on a lighter note, when we ask a question after scanning, do we also get the gifts which are on the right side of your pic?
I'll say for that you have to visit my workplace, maybe. if you get into the top rankers of this course, I will.
I was just joking. However, sir, any idea where, matlab, of course, we do not know when will the mediation council be set up
Okay.
in
Ma'am, it's
India?
a very good question. So I have to answer this with one of the event I attended last week. So I was attending an event on arbitration. One of the retired Supreme Court judge was giving a speech and he said, 2023, there was a proposal for the chairmanship of the Arbitration Council of India. Arbitration Council of India came even before Mediation Council of India because Mediation Act came later. This amendment with respect to Arbitration Council came earlier. So there was certain discussions, names floated in 2023, I think August or something, he said. But the Chief Justice at that point of time didn't approve of that. So as we talk now, there is no Arbitration Council of India. So your question of Mediation Council of India, I think we are very aspirational that we should have that. Of course, the Act provides for it. The Arbitration Act also provides for it because of the amendment. But as we talk now, there is no Mediation Council of India, there is no Arbitration Council of India, which is supposed to be the regulator of these particular domains. A lot of people I keep seeing on social media, on LinkedIn, saying that Mediation Association of India, which was inaugurated by, I think, the president or the attorney general or whatever dignitaries, they said that this is the mediation council. No, that's not mediation council. That was a private organization. Anyone can form something like an association. Mediation Council of India is a statutory body within the Mediation Act. As we talk now, there is no Mediation Council of India in place. As we talk now, there is no Arbitration Council of India. So your question, when it will be, I will say, let's hope.
Sorry for interrupting. I also got confused. That Mediation Association of India, like Attorney General of
Right.
India, and then so I was really confused. I checked
Sir,
the
I think it's
website
also
and
because if people who are experts in mediation, let's say if they write on LinkedIn that there is a Mediation Council of India inaugurated, and let's say that you are following them, so you believe that. It's very difficult to understand that which information is correct, which one is not. But I'm pretty much sure that Mediation Association of India was a private, organization. It wasn't the Mediation Council of India. But a lot of people think that is the Mediation Council of India. No. So, ma'am, it's a very difficult question to answer. But I will say that hopefully we'll see it soon. But I have no clue about it.
yes, any inputs on institutional arbitration and mediation, that role, critics, anything, how they are working?
So, for the institutional arbitrations or mediations, I will cite Khetan and Co., the leading law firm survey on institutional versus ad hoc arbitration. Just to give you a background of this, institutional arbitration is pretty much you have a special institution where you have case managers who will help you to run the arbitrations, to manage your case, send you reminders. They have a proper platform to keep documents. Everything is confidential. They also help you with physical hearings, online hearings, all of this. Ad hoc arbitrations is pretty simple. Kalpesh sir and Vikas sir wants to do an arbitration. They appoint me as an arbitrator. Who books a venue, a conference room? We have to do it. Which rules are applicable? We have to decide. What rules? Whether we have to draft rules, all of this is ad hoc. Now in India, what happens when the courts refer you for arbitration? Apart from the Delhi High Court, because Delhi High Court also has a very vibrant arbitration center, which is called Delhi International Arbitration Center. Not all the high courts have this. So they refer you for ad hoc arbitrations. So Khetan and Co did a survey on this. More than 50% of the Indian arbitrations or the parties want to have is ad hoc arbitrations. However, institutional arbitrations are more channelized, more structured. In their appointments, you have more diversity. Non-male genders are also included. But when you look at the courts, sometimes it takes time. Ad hoc arbitrations, it's not me saying this. A lot of retired judges have said that it's an old man's club. We all know this. So there are a lot of issues with ad hoc arbitrations. However, outside India, especially in the West, the most developed jurisdictions on arbitrations or mediations, you will see great set of institutional arbitrations. Just to quote, one of the best arbitration center of the world is the International Chamber of Commerce in Paris. So institutional arbitration is something which is also, catching up in India. Just to name a few, you have Mumbai Center for International Arbitration, you have IAMC Hyderabad, then you have India International Arbitration Center, and there are other institutional centers also coming up. The same applies to mediations. Now, these are all private bodies which has a list of arbitrators. You can go to their websites and you will get all of these details.
Sir, there is a question by Dr. Neem Pia. Changes in ADR scenario after Mediation Act 2023.
I will say the foremost change is that before this act came into existence, if let's say we talk about this settlement in between Kalpesh sir and Vikas sir, how will you actually enforce this? You have to go to a court and say that this is more like an agreement, a contract in between Kalpesh sir and Vikas sir. And then you have to go for a very longer route of enforcement. After the Mediation Act, there is a section provided that this mediation settlement agreement is deemed to be a decree of a civil court. So you can enforce it very easily. That's the biggest change. Of course, there are other changes also that, what disputes are suitable for mediation. It is already governed within the Mediation Act 2023. Confidentiality, a lot of things have changed, but the biggest change is this, that you get an enforceability regime for the mediation settlement agreement. However, please don't think just because you have a Mediation Act 2023, all the issues relating to mediations are resolved. I'll give you an example for this. Let's say there is a mediation settlement agreement arising out of a mediation in Singapore, cross-border mediation. Do you think that mediation will be enforced in India according to the Mediation Act 2023? The answer is no. Mediation Act 2023 only governs mediations happening in India. So this is one thing for which the government of India has actually signed up to Singapore Convention. Singapore Convention provides for enforceability of cross-border mediations, but India has not ratified it, made changes within the Mediation Act 2023 accordingly.
Sir, there is another question. Can a party who has previously consented to arbitration through a contract subsequently revoke that consent and opt for a fair trial under their constitutional rights when a dispute arises? And if so, under what circumstances?
Okay, let's use this example of Kalpesh sir and Vikas sir. Both of them signed up to an arbitration clause. Now, Vikas sir, do you think unilaterally can say that, oh, I don't want to do arbitration? Let's go back to courts. What do you think? Unilateral, you can't do anything. Forget about cancelling an arbitration clause. Even appointments are not valid because of Parkinson's. Okay, so unilaterally you can't. But let's say both Kalpesh sir and Vikas sir say that we don't want to go ahead with arbitration. Now we cancel this arbitration clause and we go back to court's jurisdiction. If both of them give consent, then there is no problem. This is how it works.
Sir, there's one more a query basically. Please guide how an advocate can pursue his or her career in mediation and where to start from.
I'll say you should start with the baby steps of reading certain good books of mediation, following up with what is happening relating to mediation from Truer Mediation blog. You can also refer to the Indian sources like Live Law, SCC Online, Manu Patra, or Indian authors writing on this. All of this is one. Then another part is training of mediation. For example, something which we are having now, or something like a 40 hours mediation training, something which is reputed. And in the Gen Z word, I'll say green flags of trainings, not some random training, but 40 hours reputed trainings. Then you have to impanel yourself as a mediator with District Legal Services Authority if you are eligible. And then, of course, you have to get certain cases to make sure that you practice it. So these will be like 3 steps which you should think about.
Okay, sir. There's a question from Dr. Shakuntala Gowda. Is institutional arbitration costly or ad hoc arbitration? What is more costly?
Of course, institutional arbitration is going to be a bit of cost because you pay the arbitrators and you also have to pay an administrative fee to the institutions. But not in all the cases institutional arbitration is going to be costly. Let's say if you appoint a retired lot of money, in that case, there may be a chance that even your ad hoc arbitrations is pretty much costlier. But in ad hoc arbitrations, will you get somebody who is managing your case? The answer is no. Please don't think that the arbitrators are going to book the venue or the arbitrators are going to make sure that they send reminders. But when you have an institution, the institutional case manager, senior case counsel, all of them takes care of this. But in short, of course, there is one fee, extra fee, which you have to pay is the institutional fee. In ad hoc, you just pay arbitrators. In institution, you pay the arbitrators plus the institution. And just to add, you can go to any of the institutional centers, MCIA, IAMC, IIAC, or ICC Paris, Singapore International Arbitration Center, LCIA, and you'll find the fees. So they have a formula, for example, 10% of the amount in dispute you have to pay for this, or 1%, whatever it is, you'll find it on the website itself. So you can assess or understand how much does it cost to rope in an institutional center for this.
So there's a question from Yash Pratap Singh. How can an advocate be a certified mediator, which you just answered?
No, I'll just add on to that, Vikas sir. So certified
Yes, sir.
mediator is having a certification of mediation of 40 hours. It can be from any of the organization. I think one of the ma'am asked that whether we have a mediation council of India. The answer is no. Now the larger question is, what are these training programs which are recognized by the courts or by the government? The answer is, I don't know. Whose job it is? It's the job of the Mediation Council of India to make sure that all of these trainings have to be accredited or accepted by them. But do we have a Mediation Council of India? The answer is no. There may be a chance that if you do the trainings of XYZ organization, and if you go to ABC organization, ABC will say, oh, you haven't done our training, so we'll not impanel you. But once we have something like a Mediation Council of India, which provides a list of training programs which are approved, you do any trainings and you go to any courts in India or any organization, they can't say no. Now, this is one of the functions of Arbitration Council of India and Mediation Council of India to make sure that these things leading to accreditations and multiple payments, multiple accreditations, one which has the standard, and that is the other organizations, all the other courts also. So this is what you have to keep in mind. Yes.
This is one last question, sir, from Mr. Gangadhar Rao. Apart from the commercial disputes, which cases need to be routed through ADR to reduce the accumulations of so many cases in courts?
I think there are plenty of disputes if we talk about this. I'll give you a classic example from the Consumer Protection Act 2019. It has a full chapter on consumer mediation. There is a mandate that all the consumer forums need to have a mediation cell attached to it. Doesn't matter it's a district level consumer forum, state level, or the national level. So consumer disputes have to be mediated. To give you an example, this Commercial Courts Act also mandates that first you have to do mediations. If you look at the Hindu Marriage Act, there is a mandate that first you have to resolve through mediations. The courts will send you for mediations, then you come back to this. Also, petty disputes relating to crime can also be settled through mediation. So a lot of them are already there. So it's not only commercial, there are multiple things for which you can do mediations.
Sir, one last question from my side.
Yes.
From the Indian context, if we look out, what do you think is the most effective mediation model? Facilitative, evaluative, or transformative?
Facilitative. Can you hear me? Can you hear me?
Yes, sir. You're
Yes,
audible.
yes, yes, yes. Right.
Yes, sir. You're audible now.
Oh, so sorry. I would say all of them are. So I'll have a lawyer's response to this. Well, it depends. It depends on the circumstance. It depends on the scenario. Sometimes when you look at the parties, none of them are ready to look at a solution. Both of them are ready to just tell what has happened and to blame the other party. At some point of time, you need to wear that evaluative hat. And parties to evaluate their options. Of course, you can't force the parties to choose option A, B, or C. So it depends on the scenario. So, but a mediator needs to understand these three models, when to use which one, and how to use it effectively.
Yes, because actually we are over to you.
Vikas sir, you are on mute.
Because over to you for out of thanks, Vijay sir has joined.
Sorry, sir. I'm so sorry. So, on behalf of the Faculty of Law, SRM University, Sonipat, Delhi NCR, and Law Teachers India, I really extend my heartfelt gratitude to Professor Akash Gupta for his valuable time, expertise, and thought-provoking insights uh, on today's topic. A sincere thanks to all our participants for your enthusiastic engagement throughout the FTP program, to our organizing committee for their timeless efforts, and to our technical support team for ensuring everything ran smoothly. Kalpesh sir, this was so you. With this, we formally conclude the faculty development program. We'll be having a
Yeah,
valedictory ceremony soon after.
yeah, we'll start right now on. So thank you very much, Akash, for your every time you are
Thank you
available
very
in our
much, sir.
programs.
Thank you.
Thank you very much.
Thank
We
you.
have with us Dr. Vijay Kumar Singh, Dean, Faculty of Law, SRM University. Sir.
Sir, yes, sir, over to you. Sir, can you take a feedback from participant if you wish
Yes, yes, why not?
later?
Please take the
Yes, sir.
feedback, Kalpesh, from the participants. Actually, I am outside somewhere
No
attending the
problem.
IOD conference today. But definitely, I have been keeping a track of the sessions which has happened. So let us take the feedback
Sure.
first, and then
Yes,
brief comments, and then we can, close the session.
yes, sir.
And if
So thank you
Akash
very
is
much,
there,
sir.
many thanks, Akash, for taking our request for taking this session. It is always a pleasure to have you.
Sorry, Akash, you are muted.
Thank you very much for this opportunity, Vijay sir, Kalpesh sir, and for curating this great program. Thank you.
Thank you very much. Yes, participant, we are like waiting for some feedback from your side. We'll be surely floating the Google form right now. But again, before that, we like to hear from you. So one by one, you can speak whatever you want to speak. We want to listen from you. Yes, participants. You can unmute yourself and then speak.
Just one line, sir, Kalpesh sir. Thank you for bringing this opportunity to us, sitting at home or wherever we are available, and attending to these sessions, and the listening to the insightful sessions, informative sessions. Thank you all for this, sir.
Thank you very much, madam. Like, there is access to justice, there is access to learning that we are doing. So thank you very much. Yes, any
Absolutely.
other participant? We'll close in 10 minutes. So please be fast. Yes, Dr.
Sir,
Sakuntala.
here I Sakuntala Gowda here, sir. Kalpesh, sir,
Yes,
you
please.
are really facilitator of all this knowledge to us. Actually, I am subscribing all the program of which one we are giving in the WhatsApp. So thank you, sir. As I am a area teacher, that is why I am so much interested in all this program. Thank you very much. And this is a very excellent FDP. I think. Another one is also you have given this. So thank you, sir. Thank you very much. Sir.
Thank you very much. Yes, any other participants? Please unmute and speak rather than chatting.
Good
Yes,
evening,
please.
sir.
Yes. And please do not appreciate me. It's all a team effort. So please, thank you. Yes,
Sir,
Gangadhar Rao.
the program is informative. However, I suggest to organize one more one with some deep subject additional chapters as a regular training program, sir, so that it will be advantage for juniors also, since the ADR is going to be the much emerging subject in the coming years. Thank you, sir.
Yes, thank you very much. Yeah, any other participants? Yes, Dr. Poonam, Dr. Kota, Dr. Prasant, Dr. Sitha. Yes, please. Anyone? We'll close in 5 minutes. Yes, Vikas, you can share your experience by that time if you want to share something. Yeah. We'll be attending most of. Yeah. Yes, sorry, you are muted.
Honestly speaking, sir, when I started my academic career, the first subject I got to teach was ADR, one of the first subjects. So I just loved this whole program, sir. Every session, especially Vijay sir, when he spoke about the detailed PPT that he shared, I still remember that is one of the perfect PPTs I've ever seen. Also, session by Dr. Jonathan was great. Dr. Nupur ma'am's session was also great. And today it was only you and I were in the session as per Akash sir, Vikas sir, Kalpesh sir. The examples he gave were very layman oriented, basically. So it was a great session, sir. Great program. And thanks to the Faculty of Law, SRM University, and to you, Law Teachers India, as well, for this wonderful session.
Thank you very Vikas, for being a part of our team member also, being a moderator. Again, like I would say this was the fastest, sir, I would say program that we planned in a week time. And because it takes time to prepare, but again, happened, I would say in a week time, like we prepare and all the resource person are done. And then in qualitative ways, it's
So
not like, one
you should
session.
thank me for that week's time. Otherwise, you were ready for within 2 days.
Yeah, yeah, yes, sir. Sir called me on 17, like I got a call from Dr. Paramjit also. Sir ने बोला है और like 20, like 4 दिन में करना है. Then immediately, sir, let me tell you, half an hour I prepared because I did program earlier also in Law Teachers India, sorry, Pro Bono India. So all the resource person topics also, I also communicated to resource person also कि भाई मैं नाम suggest कर रहा हूँ. Then immediately by the around 9 o'clock you responded with all the details. It's as a topic, refined topics and resource person, and then you can see the results. So otherwise हम 2-3 दिन में भी sir at least stated you would have done that program. So yes sir.
Yeah, so Kalpesh, I think the program went very well as we have got the feedback from the participants. Some of the participants, I'm sure you are going to give the written feedback as well. So all of you, I encourage, because this feedback helps us in curating the program better. We got one feedback saying that it should be program should be organized in a more deeper way. That is we have taken that feedback very positively, and I personally believe that all these topic of ADR cannot be taught effectively in an online mode. It has to be in a face-to-face mode, because there is a lot of body language, emotions which are attached in teaching these topics and subjects. So on a preliminary level, probably in this FDP, you have come across the nature and latest developments of ADR practice. And in coming days, probably we can bifurcate these ADR methodologies and have a specific, 3-day themed workshop kind of a thing on maybe mediation, then arbitration, then legal aid services. That can be a approach which we can follow for the training program in future, or a workshop in future. We may try to organize something on a face-to-face mode, and I think we can collaborate with the participants who are across the country and they are from different institutions. So I open it and I give it a suggestion which Kalpesh can take up, and remaining participants who are coming from different places, they can organize something at their colleges. I can give you my word that is I will be present, I will be coming, subject to availability in the calendar. And then similarly, Kalpesh can also travel. So we both can come, or we can source the speaker around your place. Something like that can also happen. So there can be a lot of permutations and combinations. So by this, we can actually promote ADR in a greater way. This is what would be one suggestion which I would like to give. As far as ADR is concerned, I think there is a lot of scope in this area, particularly in view of the national litigation policy, as well as the way we are looking towards Viksit Bharat. We need to resolve disputes faster. We need to resolve dispute for a win-win solution rather than a win-lose solution where there are a lot of appeals and appeals and appeals, because there is no end to resolving. There is no end to fighting the disputes. There has to be a way to stop it, and ADR is the best way to do that. So this is what would be my message on this valedictory session. And many thanks to all the participants who have shown an enthusiastic response for this program. Though we had a lot of registrations, but I think that there are registrations or paid registrations who wanted a certificate. But I like this concept of Dr. Kalpesh that knowledge should be free. So you have a knowledge free, and this program we were not doing it for the monetary benefit, because but idea was to reach out to more and more people on this on this concept, so that there is an advocacy on ADR. However, there are some minimal costs which are always there, and there are people who are associated with the training program. So I always say, when I teach mediation, particularly commercial mediation, I say that the mediators don't come for free. If you go to a lawyer, the lawyer will charge you lakhs and lakhs of rupees. But at the same time, when people go to a mediator, they resist paying the mediator's fee, or they feel that, okay, fine, this is something which is resolved and we don't need to pay the fee. This mindset needs to be changed, because anybody who is trying to give you services, there has to be some remuneration which has to be given to that particular person, or it has to have some mechanism in place. So with that objective, I think it is a great model where you give knowledge for free, and at the end, if someone wants a certificate to that effect, where a minimal charge is taken. I believe that is a great opportunity. So again, I would implore the people who want to have the certificates, they can just register it and will be granted a certificate as promised by Teachers India and SRM University. We look forward to the future programs in SRM University as well as in collaboration with Law Teachers India and all other participants who come from different parts of the country. We can enter into a collaboration, so we can do a joint program, because that is also a way of moving towards collaboration. So this is something which I am open to, and we are open to as an institution. So with these words, over to you, Kalpesh, to conclude the program. Thank you.
Yeah,
If
thank you,
anything
thank you.
else you want to ask me, or any participant want to ask me, I'm open.
Yes, thank you very much for your insight and inputs.
Thank you, sir.
So I
And
request
I also want
Dr.
to
Paramjit,
thank you,
over
sir,
to you.
for
Yes, yes.
joining at such a short notice. I see you are outside, and despite that, you have taken some time for us. Thank you so much for taking the time out. Thank you so much.
Yeah, thank you very much, Dr. Paramjit, Vikas, and all the moderators, and thank you very much, Vijay sir. This is the second program, as stated earlier. Great, I would say we planned for 2 weeks and then we extend for 3 weeks. And uh, very good topics, I would say. And the resource person from all over the India. So stalwarts in legal research. So it was a great program. And after this, again, the second success. So thank you very much, sir, for your support. And then thank you, participants, for joining. And some participants are constant, regular attendance of the program. So it's a great thing. It's really encouraging. Nothing like, it's become like sorry, a participant, I'm not able to save all the numbers because I let me tell you, so far maybe last 2.5 years 15,000 registration would have been there in collecting all the programs. So who are connecting, chatting with me, so, and then I save, and then things are happening in a building relation. So and then keep communicating with the help of WhatsApp group that I've created. WhatsApp group 1, 2, 3, 4. WhatsApp channel are also created and spreading all the programs and what we are doing and all the literature, whatever we are doing last few years. Thank you very much once again, sir. Forward to see you in future. Thanks.
Thank you so much, sir.
So thank you, everyone. I'm signing off. All the best
Thank-
and looking
thank you,
forward to you in the future programs. Thank you.
Thank you very much.
Thank you.